Going to bring you in here. I was going to ask you, what can we expect from the status hearing today? But I was beat to the punch by Deborah Stroud 10, who said, what is the sole purpose of a status hearing?
Well, really, the purpose of this status hearing, it can mean a lot of things at different points in a case. But for this one, Ann Taylor, the attorney for Bryan Kohberger, asked for a status hearing at the initial appearance last week because she said they were new to the case. And the judge had initially asked, hey, are we going to set a date for a preliminary hearing? And she requested a status hearing because they are new to the case. So they are only going to be basically setting a date today for a preliminary hearing if they don't waive the right to that hearing. Should they waive the right to a preliminary hearing, an arraignment will be scheduled. But if they want a preliminary hearing, and that's where the prosecution has to put on evidence to show that they have probable cause to arrest Bryan Kohberger, they believe he committed these crimes, and then the judge has to determine whether or not they've met that really low bar, the prosecution. They could want that hearing because they could want to question a detective who's put on the stand. There are any number of reasons why they may possibly want a preliminary hearing.
And we know at this point, Mr. Kohberger has not entered a plea as of yet, although the indication
Correct.
is that he is going to fight this. We know that his attorney has actually come forward and done an interview and said that they believe there are holes in the probable cause affidavit. Bobby, I'll go to you. We have a question from DTS talking about the potential preliminary hearing that Anjanette mentioned where the government would come forward with the evidence of probable cause. If there is a preliminary hearing, Bobby, DS asks, will DM need to testify? Now, DM is that surviving roommate that was mentioned in the affidavit who allegedly saw the suspect. You tell me, will DM need to testify?
Yeah, I don't think so. I think that the preliminary hearing is kind of like an in-person version of the affidavit that we've all seen, where a magistrate has said there were a probable cause to move forward. In that affidavit, as you saw, the DM was allowed what we call hearsay, right? So it's not the witness themselves saying it; it's the detective saying, "I interviewed this person and they said this." I think, if I'm not mistaken, at a preliminary hearing, they can introduce hearsay into the record. Eventually, of course, at court, in a court of law before a jury, hearsay is not allowed. And hearsay is just me saying what I heard from somebody else and not hearing it directly from that person. So I think that hearsay would be allowed in a preliminary hearing. Again, it's a very early stage. He hasn't even been officially arraigned on the charges yet and entered a plea. So I think that what you'll see is the detective that swore out the affidavit take the stand and go through what you saw in that affidavit.
And some preliminary hearings longer than others. Some almost seem like a mini trial within a trial. Not quite the situation here, but maybe. I want to go more to our questions from YouTube. We have Mike Johnson and Jeanette who says, please explain the difference from the gag order from the order to seal. There's been a lot of confusion over this. If you can do your best, Anjanette, to explain what the difference is between the gag order that was issued by the judge with respect to any comments made by people connected to the case and the order to seal with respect to certain documents.
Well, gag orders happen sometimes in high-profile cases, and that basically says that members of the prosecution and members of the defense, police, investigators for the defense can't make comments outside of court. They can't grant interviews where they're saying, we think Bryan Kohberger is guilty because of this, that, and the other. Or the defense says he's innocent and, the police messed up because of this. And I'm just giving an example there. So it just covers statements made out of court, not documents filed within the court. A document being sealed, such as the search warrants in this case, that's different. That just means that those documents can't be seen by anybody right now, except for the people who filled them out and the people in the courts. They're usually placed in some type of envelope, so they, can't be viewed. So that just means there's information in there that we want to keep secret, and we believe there are reasons why, and they have to present the court with reasons why they're requesting a document to be sealed. There is an apartment, the apartment belonging to Bryan Kohberger in Pullman, Washington, a short distance from Moscow, Idaho. The search warrant in that case remains sealed until, I believe, March 1st of this year. And they were saying they obtained this search warrant back on December 30th, I think, or maybe it even been the 29th, before the arrest was made, and they were afraid that they might tip off the suspect should it be revealed and be open for public inspection. So they were looking to protect the investigation, protect law enforcement. And so that is why that document can't be viewed at this point in time. So gag order covers statements. Documents are covered by a seal by the court.
All right, thanks for that, Anjanette. What we're going to do is we're going to take a break. Again, we're carefully monitoring any updates that we're getting from that status hearing that is happening, and we will let you know the latest on that. We will take more of your questions, and Bobby, I'll tell you, I got a great question lined up about evidence in this case, so we'll take a quick break. We'll be right back right after this.